Probably many of you know him well. To participate today, you can leave a question in the Q&A. You can upvote questions if you find them interesting. And we're going to ask you to use the chat fairly often. So please locate your chat. Sometimes it's on the bar at the bottom, and sometimes you have to go to the little ellipses, the 3 dots that say more to open up your chat. We'd like to see who's here today, what subjects you teach. So you're about to have a poll pop open on your screen. And if you could take that poll quickly, and also if you would like to introduce yourself in the chat, we'd love to see who's here. Great, government and economics, excellent. Okay, do we want to go ahead and post the results of the poll? If you didn't have time to register, we're really short on time today. So if you didn't have time to answer the poll, just drop your information in the chat and we'll take a look at it. Good, so history, law, elective, other, great. Thanks. So we're gonna talk about a lot of different links today. So we wanted to give you those links all in one easy place and all the materials we're gonna talk about today. So you have 2 options for accessing these materials, none of which you actually need for our session at the moment. But you can use that QR code, and you can do that by putting your camera on. You don't even need a QR reader, and just aiming it at the QR code. It will bring up the PowerPoint we're using today and a list of the links and those links will take you to some articles, some webinars, all sorts of things we'll talk about during today's session. And if that doesn't work for you, there's a bit.ly. I also dropped in the long version of the materials link into the chat, because I know earlier some people had schools that blocked bit.lys. So.
Okay, well, today's agenda, we have a pretty ambitious agenda. We're going to try to get this done in 45 minutes or in 38 more minutes. And we're going to start with a brief sort of opener. How well do you know your Supreme Court? 6 questions that some of you will find very easy and some of you might not know, but that's fine. You'll get a chance to learn the answers today. And then a quick preview of the term, sort of from 30,000 feet, just to give you an idea about what's happening in this term. And then we're going to move into the case that we're going to focus on, Torres versus Madrid, and especially focus on a case study approach that we use called classifying arguments. And then finally, at the end, we will have a minute or 2 to talk about what's new at street law. All right, so here is our how well do you know your Supreme Court? And if you'll just put in what you think is the right answer for how many petitions for cert the court will review this year, and then how many cases will the justices decide after a full briefing and oral argument. Click on what you think the answer is. And I think we should see the results of the poll now. Is that right, Kathy?
Yes, BK will launch the answers to those polls. There we go.
All right. So how many petitions? It will be about 8,000. So almost half of you got that right. How many cases will the court decide? Between 60 and 80, almost certain to be right, and 80% of you got that right. So that's terrific. Let's move on to questions 3 and 4. Will more of the cases accepted come from the state court system or from the federal court system? And will there be more 5-4 decisions or more 9-0 decisions? So let's see how we've done. Yep, so the majority of you got this right. It's actually between 80 and 90% of the cases come from the federal courts. In the first 44 cases that they've taken this term, only 4 have been from state courts. So far this term, 91% from federal courts, but always more than 80%. And then the well, I didn't quite see the answer to the 5-4 versus 9-0. Can we get that back for just a second? There'll be absolutely more 9-0s, generally twice as many 9-0s as 5-4s. Okay, let's move quickly to questions 5 and 6 and put the poll up. So how will the justices decide the cases that they accept? Will they affirm, will they reverse, or will it be about an equal number in each direction? And also, what happens, or what would have happened in 4-4 decisions before Justice Barrett joined the court? And let's see what we think. Well, nobody got this right. That's great. Lots of candidates for our Supreme Court Summer Institute. They usually reverse the decision of the lower court about 3/4 of the time. This hardly ever varies. So the hardest thing is to get your case heard. But once you get it heard as the petitioner, frequently, more than half the time, the court reverses the decision of the lower court. And now let's take a look at what happens when divided by an evenly divided court. And everybody got this right. Does not create a national precedent. It affirms the lower court decision, but does not create a national precedent. Everybody got that right. So great. Well done. So let's move on to the preview of the term. We just had a couple of quick slides. We're going to move through this quickly. As I mentioned, so far they've agreed to hear 44 cases, which puts them, I would say, on track to decide about 65 to 70, which is about what they've been doing in recent years. In terms of oral arguments, as you know, they stopped hearing live arguments in the middle of March, just when we all stopped going to work also. Just a couple of comments on this. You can read the bulleted items. Now that the Chief Justice is calling on justices in order of seniority, Justice Thomas is participating more. He doesn't pass, he asks questions. So that's different because typically in the past, he asked very few questions. And they just announced they're also going to have telephonic arguments in January, but I think it's most likely that they will have telephonic arguments for the entire term, which would put them into April sometime. So let's move on to the next item. The shadow docket. This sounds sort of ominous, but actually some of you have probably read articles indicating that the shadow docket is growing. And you can see Kathy Ruffing's clever visual here with the shadow in the background. But what the shadow docket is any case that the court decides without the benefit of oral argument. And shadow docket has traditionally been mostly cases from people who are about to be executed, stay of execution cases. But the number of shadow docket cases has grown with cases that relate to COVID-19 and also the election and other things from the Trump administration. So we're going to hear about one of those cases in just a minute. But that's what the shadow docket is, and it's likely that people will write about this phenomenon growing this term. You'll see it in the newspapers.
And in our links, we linked to 2 articles that are not our own, but from friends of street law who go into a lot more depth about the shadow docket, and because we wished we had more time to talk about it.
All right, standing. Well, here's another one of Kathy's clever visuals. You can see a person standing in front of the court, and actually you can also see his shadow. So you could use this for the shadow docket or for standing. It's not really important for students or high school teachers to have a detailed understanding about what standing is. I think what we generally need people to know is that the court does not give advisory opinions. There has to be a real case. Law students learn that to sue in federal court, you have to have a concrete, not just a hypothetical injury, but a real injury, a harm to some legally protected interest. that the defendant who you're suing has caused, and it's got to be a case that the court can resolve, which sometimes means that there's a separation of powers objection to a case. And the Roberts Court is very tough on standing, and you'll see in a lot of cases, one of the issues is this plaintiff properly before this court? So it's common for this court, not particularly more common this term, but very common with the Roberts Court. And then finally, let's look at the cases that are making headlines. The things, you probably know some of these because they've been in the paper. The things I want to point out are the second bullet, the religious liberty claim by a foster care agency. Looking back a few years back, this is likely to resurface some of the issues raised in the wedding cake case from Colorado. And this may also raise issues that come up in the future in religious objections to vaccination cases. We don't have those yet, but I think it's possible that we will see those. And then the last bullet, the case just decided a couple of days ago without oral argument. So from the shadow docket, the court said that Governor Cuomo cracked down too hard in terms of occupancy limits on religious gatherings. What's interesting about this is that earlier in 2020, in cases from California and from Nevada, the court 5-4 deferred to the governor's occupancy limits. And when Justice Ginsburg died and Justice Barrett came on, that 5-4 has now flipped. It's now those that were in the majority are now the dissenters. So those are the cases making headlines. The court grants cert until the second or third week in January. So they haven't agreed to take all the cases they're going to take. They're probably going to take about 20 more cases. So keep an eye on that. And keep an eye, of course, on SCOTUS blog, which is the great website that helps you keep track of everything related to the court. And now let's go over to Kathy and our case.
Great. So we're going to take a quick but deep dive into Torres v. Madrid. So at Street Law, we pick a couple cases each term to write case summaries for. And we pick these cases because, they have some potential to be important because they're high interest for students and the facts and the legal issues are accessible for students. So the first case we had on our fall SCOTUS in the classroom is Torres v. Madrid. It was argued on October 14th. And it is a Fourth Amendment case. I put this picture here to show you that this is what the student document looks like, which you have a link to. So it's a Fourth Amendment case. I'm sure based on who we saw was in our audience, you're all very familiar with the Fourth Amendment and what it says. So we just highlighted the words that are going to be really pivotal to this case, which is about seizure. Generally, the Fourth Amendment cases are about searches, but this is a seizure case. So that people have the right to be secure in their persons against unreasonable seizures. And that's what this case is going to boil down to. So what is a seizure? This is the first thing your students are going to ask you. There are two categories of seizures, and one is the application of force to a person's body. And that is going to be what this case focuses on. The other one is a show of authority. So this is sort of like if you think about the 50s cop shows and they say like, stop in the name of the law. When a police officer asks someone to stop and they do. So for number two, it's been clearly established through precedents that there needs to, the suspect needs to submit for that seizure to have happened. So if a police officer says stop in the name of the law and you keep running, there is no seizure. If he says stop and you stop, there is. So this case is going to kind of take that concept and decide whether it applies also to cases where there is application of force. So that's a little bit of foreshadowing about this case. So unreasonable, the other part of that case was it needs to be unreasonable. So there are a couple things that maybe make a seizure reasonable or unreasonable. First of all, is there a warrant? If there's a warrant to seize either property or a person, so that would be an arrest warrant, it's pretty clear that that's reasonable. as long as the warrant was properly obtained. Is it warrantless? So if there is, there are lots of exceptions to the police needing a warrant, a lot of proper warrantless searches and seizures. But those are fairly established. The next one, what was the use of force? So this case is also going to confront the idea of excessive use of force, which is one of the next slides. So I won't talk about it too much here, but, was the level of force in ratio to the seizure? And then, of course, a lot of this comes down to, these questions come down to, what is the reasonable person test? So what does this fictional reasonable person, who the court talks about all the time, what do they think about this seizure? If they look at it, do they think that it was reasonable under the given circumstances or not? If you listen to oral arguments, and one of our links is a link to the OYA audio of the oral arguments. I listened to them again last night and this morning, and there is a lot of talk about this fictional reasonable person. And you won't be surprised to hear that both sides thought that the reasonable person was on their side. Okay, and excessive force. So what do we mean by excessive force? Excessive force is greater force than is necessary. And of course, that's going to be deemed whether it was necessary by that reasonable person test. That's important because if there was excessive force, it opens police officers up to being sued and having civil rights claims made against them. And that's going to be part of this case as well. When a police officer uses lethal force, like a gun, which is part of the fact pattern of this case, then the force that must be reasonable in light of the circumstances. So sort of a litmus test for this is that, an officer can't shoot an unarmed person fleeing on foot. That would be excessive, but they can shoot someone trying to run them over with a car. So those two things both sort of come into the fact pattern of this case. So it's going to be really important to decide whether or not a suspect is seized, because because citizens or people can't bring constitutional rights violation cases against an officer unless that officer has violated the Constitution. So in a case of a seizure, that would be the Fourth Amendment. So that's the big who cares. So why does it matter in this case? It matters if the person is seized, because if they are, then the officer can be brought up on civil rights charges, and a claim can be made against them. So the person bringing the case has to show that the officer stopped their freedom of movement by use of excessive force. So they must be seized. So that's a background for this case. Now we're going to look at the facts of the case. We're going to deep dive into Torres v. Madrid. And I have to say that I read the briefs on both sides of this case and listened to the oral arguments for both sides of this case. And this is very much a she said, they said story. If you read these two briefs, you might think that you're reading about two different events. So I'll try to make it clear what both sides agree to on this and where there are differences in what happened, so you can see. So that's a picture of Roxanne Torres. That is her mugshot. So here's the story. So in July of 2014, two officers, and there were other officers present, but these are the officers that are closest to the situation, Madrid and Williamson, go to an apartment complex, and they go there to arrest a completely different woman who Torres doesn't know, isn't there to visit or anything, but they see her they see her there, and they think maybe she either has information or is this other woman. And so they approach her car. When she sees these two people in dark clothes with guns approach her car, she gets in, rolls up the windows, and starts the engine. It is 6:30 a.m. Both sides stipulate that it's still dark and relatively difficult to see. Torres claims she thought she was being carjacked and was afraid for her life. And the police officers, Madrid and Williams, say that they gave a lot of verbal orders, such as show me your hands. So their stories conflict there. And they were just in tactical gear that had a small insignia that identified them as police officers. There is some debate about where the police officers are located, but it could be important to how you think about this case. So I'll say that most agree that Officer Madrid, who was female, was standing sort of by the driver's side front wheel. So not in front of the car, but in the front side of the car. And Officer Williams was standing somewhere at the rear of the car. So at that point, Torres drives forward. And as she drives forward, this is all stipulated. Both sides agree that this is what happened. The officer shot 13 times. The police officer said they feared for their life and thought they might be run over. The two of the bullets went through the car and through the seat and struck her in the back. Torres claims that oh shoot, I wasn't putting those up there, sorry. Torres claims that one of those shots paralyzed her arm and that she was immobilized for at least a little bit. She drives a very short way and she collides with a car. And so she gets out of her car. She sees someone loading another car with the keys in the ignition. So she jumps in that car and steals that car. She drives 75 miles away to a hospital. Arguably, it's not the closest hospital to where she was. But she goes to this hospital. She checks in under an assumed name. But the next morning, the police figure out that she's their suspect and they arrest her. She pled no contest to 3 charges, aggravated fleeing from a law enforcement officer, assault on a police officer, and unlawful taking of a motor vehicle. So she files that civil rights complaint for the excessive use of force against Madrid and Williams. And then comes the next part of the story, which is the first thing they have to decide is, was she seized, and therefore has the ability to bring this excessive force claim. So I'm going to turn it back over to Lee to talk about how it got to the Supreme Court.
Okay. So this case got to the Supreme Court in the way most cases get there, which is through the federal courts. About 80 to 90% of the cases that the court takes come through the federal courts, and they begin in the trial court, which is called the United States District Court. And then from there, the officers filed a motion saying she was not seized, and that motion was granted. And then she appealed to the United States Court of Appeals for the 10th Circuit, which affirmed or agreed with the trial court's decision. Now, the next step is to try to get it to the Supreme Court. And earlier in the session, we remembered that 8,000 people are knocking on the door and only 80 get through. So why does the court take some cases? They take cases because they're like this one, in that there's a circuit split. And as you can see from the graphic, the 8th and 9th Circuit and the New Mexico Supreme Court have ruled that these kinds of things are seizures. We don't say it here, but there's in their circuit and in the District of Columbia Court of Appeals, which is the Supreme Court in effect for the District of Columbia, the courts have ruled that these are not seizures. So you have the highest courts, short of the Supreme Court, ruling in different directions. This is called a circuit split. These are the kinds of cases that the Supreme Court takes because they want to have uniformity of the law. And this is an issue that has come up enough in the courts that they think it's ready to be decided. And so the court agrees to review this case, which is called granting a writ of certiorari. This is the legal question that the court has to deal with, which you can read. And remember, as Kathy's emphasized, she can only win her civil rights suit if there's a violation of a constitutional right. And the constitutional right would be the Fourth Amendment right to be free from unreasonable searches and seizures. She argues that the shooting and the facts as described constitute a seizure. And they argue that she drove away. Police argue that she wasn't seized. So now we're going to look at actually some of the arguments that were presented in the case. Kathy's going to take you through Kathy and I are going to take you through these. This is our classifying arguments methodology, and it helps students think about the arguments for each side and identify whether an argument supports the petitioner or the respondent. In this case, Torres, the fleeing suspect, or Madrid, the officer, Madrid and Williamson, the two officers. So Kathy, why don't you start?
And I do want to say that I put fleeing suspect to help you remember who was who. But remember, Torres says she actually wasn't fleeing as a suspect. She thought she was fleeing from carjackers. So I just wanted to make sure that people knew that I wasn't making any kind of editorial comment there. Okay, so for number one, for a seizure to have occurred, the officers must have acquired physical control over Torres through means intentionally applied so that Torres did not feel free to leave. Torres's freedom of movement was not restrained, evidenced by the fact that she fled the scene and drove more than 75 miles. So just go ahead and just drop in chat. We're not going to bother to post polls for all of these, but whether or not you think this argument supports Torres or Madrid, and we're going to do this a couple times. So you might want to put 1A if you think this this argument supports Torres, or 1B if you think it supports Madrid. Great, they're populating there.
Lots of right answers.
Right, everyone's in agreement. Yes, this obviously helps the police officers. So I'll send it to Lee for number 2.
Yeah, so let's look at the second argument. A seizure occurs when force is applied with the intent to restrain. I can't quite see it, all this, because our pictures are in the way. When the police officer shoots at a suspect with the intent to restrain them, the shooting is a seizure, even when the suspect does not immediately stop. This is an argument for Torres, or is it an argument for Madrid? This is a very smart group of people in this session, Kathy. Yes, everybody's got it right.
Good, great. Okay, so we didn't put the precedent here, but we will tell you that the main precedent in this case is a case called Hudari D, and both sides use it extensively. So they disagree with who, it can be sort of molded both ways to help both sides, like a lot of precedents, right? So even if the precedents require some restraint on movement, when the officer's bullets entered Torres's body and temporarily paralyzed her arm, her movement was restrained. Does that help Torres or does that help Madrid? Good, lots of Torres is there.
Okay. The fourth argument, had Torres stopped immediately after being shot, she would likely have been considered seized for purposes of the Fourth Amendment. However, she did not stop. It's an argument for Torres or an argument for Madrid? Again, everybody's getting them right.
Good. And I just want to mention that if you listen to the oral argument, Madrid's advocate says that she was stopped for a non-zero minutes or something, or moments or something like that. It was the non-zero. Okay, number 5, Torres's own account of the incidents and her conduct show that she felt free to leave and that she did not perceive herself as being seized by the officer's gunshots. As a matter of fact, she said she didn't even believe they were officers.
Correct.
Okay, great. And last one.
Seizure was unreasonable because Madrid and Williamson used lethal and excessive force when they shot at Torres 13 times as she was fleeing. Because they were standing at the side of the car, not the front, the officers' lives were never in danger. Is this an argument for Torres or an argument for Madrid?
Great.
So everybody got all of these right. And I think maybe this is an activity that's sort of an entry-level activity for teachers, but a good activity for students who should be able to do this before David Scott says we're a smart group. Exactly right. That's for sure. But for students, this helps get them on the way toward actually making arguments for each side, and ultimately perhaps toward putting together and presenting a moot court. So this is part of the scaffolding process of getting people ready to do a simulation of a Supreme Court argument.
Yeah, and this is what what the sheet would look like if you printed it out from your students. We gave you a link to this in the materials, and you'll see that some of them are more difficult, but because we didn't have a lot of time to go into the precedents, I on purpose didn't incorporate any of the questions that talk about precedent. But for those of you who teach that's important, you know, the stare decisis and the idea of precedent, you'll see, even though this is probably small and difficult to read, that some of the questions rely on precedent. So this is sort of the handout that you do if you are face-to-face with your students in the classroom. We also have activities. We've also done this activity with Poll Everywhere contest or Poll Everywhere pairs. I mean, there's lots of things that you can do, you know, to adapt this virtually. And we have a lot of ideas about that in our Teaching Online website, which is also in your list of material links. And if you would have liked to know more about the case, and we're frustrated that Lee and I kind of went through that super quickly, there's also a link to a YouTube webinar that we did with an expert, Jeff Green, who wrote one of the amicus briefs on this case. You can watch a whole hour that goes into a lot more detail about this case in particular and has a question and answer session from teachers if you're interested in more information about the case. Okay, so we'd like to know your ideas after you've seen this about two important questions that sometimes have different answers. One, how should the Supreme Court decide this case? And the other, how will the Supreme Court decide this case? So you're going to see a poll come up that has two distinct questions. We'd love to get your input on, if you were a justice, how you think they should go, and then knowing the current court, how you think they will find. And BK, whenever you feel like people have answered, whoever's going to answer has answered, you can feel free to publish those. Great. Well, that's great that we have we have people on both sides of the argument. Lee, so, what do you think about their prediction?
I think the prediction maybe is right, but I think it's easy to say, well, you know, now there's 6-3 conservative tilt to the court. President Trump got 3 people confirmed, but you can't always tell about people once they get on the court. I mean, certainly last term, no one thought that President Trump would have nominated the person who wrote the LGBTQ case and employment law. These things don't always work out exactly the way presidents want them to. And also, Justice Barrett clerked for Justice Scalia, and he, in some criminal procedure cases, turned out to be defendant friendly. So I don't think we really know how this court will sort of settle in with the new members and where the sort of point of inflection is going to be. Who's going to be the swing vote, or who are the swing votes? But this case will be an interesting one. And I think probably if we polled a lot of experts, they would have the same expert opinion that this group has, that most might think that the police officers will win, but there is a certain amount of outrageousness to what happened. And I think if you accept the facts from the way Torres describes the facts, I think there's a natural sympathy for her believing that perhaps this is a carjacking and that she needed to protect herself. So, you know, it not only depends on the law, but it also depends on what version of the facts you find most convincing in this case.
And Lee, this case was argued on October 14th. What's your prediction of when we'll have a decision in this case?
Well, not yet.
That's true.
Yeah. Sometimes you get them in 8 weeks, which would put it in the middle of December. But I don't think this case is that easy. and I think it will be into next year at some point. Was this argued, Kathy, before Justice Barrett was on the court?
Yes.
So remember, a 4-4 tie is also a possibility where this case would affirm the decision below by an equally divided court and not set a national precedent, as we learned earlier in this session. So that's a possibility. This material is absolutely on our website and free. So let's go on to the next thing, Kathy.
Yes.
We're in good shape time-wise, I think.
Yes. So this is the place on our website that you can find it. It's not maybe very intuitive, but if you go to the street law website in general and you go to our work and curricula and teaching materials, then you can go to SCOTUS in the classroom. And as I mentioned, SCOTUS in the classroom are cases that we choose because they are interesting to students, or at least we're hoping they're interesting to students. They're accessible. The facts aren't too difficult. The legal issues aren't too difficult. And they're cases that we feel like could be mooted in a classroom. And so we try to pick cases, like this one, that you could easily do a moot on in your classroom. I wanted to mention that another case that is about to be up on SCOTUS in the classroom, we're actually just waiting for the merits briefs to drop. It are Lang v. California. So this case was accepted, and we're just waiting for both sides to put in their side of the story so that we can make sure that that we have our case summary as accurate as possible. I'll also mention that one thing I didn't know as a teacher for all the years that I used street law materials as a teacher is that we go through a rigorous review process, legal review process, where we have people who specialize in this area of law look at the summaries and make sure that they are legally correct, because it can be a kind of a tightrope walk to get things to a 10th grade reading level, but also keep all the legal nuances. So once it is reviewed, it will be up on SCOTUS in the classroom. This is a super interesting case that I think your students will care about, because a guy was driving around honking his horn with loud music, and a police officer followed him into his garage. And this case ends up becoming about unreasonable searches. So I thought it was a good companion case to our unreasonable seizure case. And the question ends up being whether or not a police officer can use hot pursuit as a warrant, as an exception of the warrant requirement if it's a misdemeanor that occurred, because it's pretty clear that they can if it's a felony. We also wanted to mention to those of you who haven't been to the Supreme Court Summer Institute, I know that I see some familiar name who has been, but we are hoping to have our Supreme Court Summer Institute this year in person in DC. If that isn't possible, we will pivot to virtual. But we're looking for 60 teachers across the country to take a deep dive 6 days into the Supreme Court. When the world is normal, we hear decisions handed down in the courtroom. We have a reception with the justice. We go on tours of the court. I'm not sure how much of that will be possible this year, but we would love to have some of you apply. It was my entry into street law in 2002, and it revolutionized my teaching, and that's not hyperbole.
So the dates are June 17th through 22nd. It's the first to institute. The second is June 24 through 29. There might be a third option. It might be either these dates or it could be virtual. We're also talking to the Supreme Court Historical Society and the court about the possibility of moving it back 5 weeks or so to perhaps the last week in July, the first week in August. We would lose being in the courtroom to hear the final decisions, but we might be able to do it in person. It really depends completely on, the level of COVID that's circulating, how quickly the vaccinations get out there. There's a lot of things that make it difficult to predict right now, but we are trying to think about a third way. And I just talked to the Supreme Court Historical Society yesterday about this. So keep an eye on our website. Please do apply if you haven't before. And I know about half of you who are in the session have already been there. And it's great to see you. And thank you for coming to this session.
Okay, really quickly before we let you go, we wanted to mention, a lot of you probably know that we co-host landmarkcases.org with the Supreme Court Historical Society. We've just completed a major overhaul and an addition of 3 cases, Obergefell v. Hodges, Engel v. Vitale, and Schenck v. US. Added a lot more very street law specific activities. So please check it out if you haven't been or you haven't been there in a while. On Monday, I am doing a sort of guided tour of landmark cases. So please follow us on social media and you can find all the information about that, how to register for that free webinar and much, much more. You can also sign up for Educator updates. If you go to our landing page, you can find this. It's also in the links to all of the materials, and that will get you updates on all the things we're doing. So we want to thank you so much for coming. There's my email. I will also drop it in the chat. So please feel free to reach out if there's anything that you need. This was a very short session and we tried really hard to cram in everything, but I'm sure we left some stuff out. So if there's anything that you need, please reach out to us.
Thanks, everybody, and be safe.